So, I will come back to something which I announced this morning already, which is the notice on cooperation with the national judges and the study we have been carrying through last year. So I will first speak about the background, the tender procedure, technically, the methodology used, and the content of the studies, the main trends we have seen, and so on. So just to let you know the background, the first notice on cooperation was in 1995. It was very short, a few pages, and it was mainly explaining the state of the case law as regards the division of competences between the national judges and the Commission, and it was also suggesting a certain cooperation, but without formalizing it, without putting any delay. But it was already a first step. It was followed then by the first procedural regulation in 1999, and in 2006, as Jacques said, there was the second already, excellent study on the enforcement of state aid law at national levels, where they took, I think, 15 member states at the time. There was an extension of the study in 2009, and it was followed by the notice on the enforcement of state aid law by national courts in 2009, which is still in force currently. There was the new procedural regulation in 2015, and 10 years after the notice, we decided to carry out a study on the enforcement of state aid rules. Just a brief reminder, as you know, the Commission and the national courts have distinct but complementary roles as regards state aid. So both can carry out can carry out assessments of the notion of aid, of unlawful aid, and also implementation. Both are also responsible for the recovery decisions, the national courts for the implementation, and the Commission, of course, for drafting it. The only exclusive competence of the Commission is the assessment of the incompatible aid. So everything which regards compatibility is exclusively in the hands of the Commission. However, I should make a small caveat. With the extension of the aid, which is granted through the general block exemption regulation, the national judge has in fact to verify if a given measure complies with the criteria of the block exemption regulation and therefore could be exempted from notification. So in a way, the distinction between the assessment of the compatibility by the Commission and by the national courts becomes tighter because when they have to evaluate a measure under the GBER, in a way, national courts are carrying a similar assessment of compatibility. But this is a personal remark, just to say that the frontier might not be that clear anymore. So, in February 2018, we launched the tender procedure, followed by the signature of the contracts in July 2018. The final study was submitted in April, approved in June, and was published on the DG Comp website in July. Okay? So it was a consortium of different beneficiaries who won the contract, among which the University of Florence, Ecoris, and I don't know, still two others. It was under the leading of Professor Parcou and Marco Botta. What is the methodology which has been used? So there are two types of research they went through. First of all, they did in the 28 member states a research in the national rulings regarding public and private enforcement of state aid rules and decisions. So yes, maybe important to say, so you have the study here, it's published on our website. They make a distinction between public and private enforcement. So it's the consortium who has made this distinction, which we do usually not use. But by public enforcement, they mean everything which is related to the enforcement of a recovery decision, which is in a way triggered by the public. That's why it's called public enforcement, because it's the member state who issues the recovery order, and then, of course, the beneficiary may appeal it, but the source, in a way, is public. Private enforcement is pure litigation issued by private parties, for instance, damage claims, request for suspension or interim measures when illegal aid is granted. Okay? So just to put you in perspective the distinction which they have established between the two. So they have found out 766 relevant rulings. So they mainly went through only second level jurisdiction and highest court jurisdiction. If there was really something very interesting, they also put first level jurisdictions, but mainly second level and highest level. And out of that, they selected 145, which have been then discussed in extenso in the study. The second thing which they did was an online questionnaire and interview with the judges to assess the use of the cooperation tools. So if you may remember, in the cooperation notice, we have introduced the cooperation tools, which is the request for information or the request for opinion, and the amicus curiae. Later on, it has been formalized in the procedural regulation, but we have asked the tenderers to really assess the use of these cooperation tools. How was it used? Was it frequent? Why is there such a low use of these? So 78 surveys have been completed, and there were 27 interviews. So the main trends in respect with the study of 2006, first of all, we can say that there is an increase in the number of judgments, mainly in the private enforcement cases. Okay, so 706. What they see also, the repetition between the private and the public enforcement cases, there are 3 times more private enforcement cases than public enforcement cases. So just to give you a number, I think there were 172 public enforcement cases and 594 private enforcement cases. Well, the reason for that might be very simple. Public enforcement cases are based on a recovery decision. So if there are not that much recovery decisions, there is, of course, lower litigation based on public enforcement. The remedies have been rarely awarded. That's also very worrying. So when the argument is brought up by the parties before the national judge, in, I think, 64 of the private enforcement cases, no remedies have been awarded. So the claim is simply rejected. While in the public enforcement cases, it's only 30% which have been rejected. So difficult to draw conclusions from that, but it may well be that indeed when public enforcement is concerned, well, there is a strong legal basis according to the judge, because we can come with, they can come before the national judge with a commission decision, while in the private enforcement cases, well, it's more difficult for the judge to start from scratch in a way. So that's why probably there is a lot of those claims which have been rejected. Which are the difficulties encountered? Concerning the public enforcement, we have issues concerning the calculation of the recovery interest. There are also many issues on the insolvency cases. I think when explaining in the past session the problems related when the company is in insolvency, well, it may indeed be very difficult for the judge to apply correctly the recovery obligation when it comes to insolvency cases. Other difficulties are the identification of the beneficiary after insolvency. There is also the lack of clarity of the recovery decision and the recovery order. This might also happen. Sometimes in the recovery decisions we are not perfectly clear, especially when it comes to schemes. And many judges also do not know how to handle claims against the recovery order when the case is pending before the EU courts. Some judges have the tendency immediately to suspend the appeals against the recovery order, but of course we will see that's not the right thing to do. Okay. Which are the difficulties encountered with the private enforcement? As we said before, the definition of aid includes very complex assessments for which the national judges are not really weaponed for, so they may have difficulties in assessing the Altmark criteria, for instance, because state aid, as we said before, is spread over the different courts. It's not only the administrative court, it can be the private civil law courts. So, and it may well be that a judge only sees a state aid case once every 3-4 years. So it's very difficult for the judge to go into the complex assessments. Very often we have claims which concern requests for extension of the aid. So the competitor comes to the judge and says, okay, my competitor has received aid, why didn't I receive aid? Of course, the national judge cannot allow for granting of new aid. He can only try to recover the aid or suspend the aid to the competitor, but that does not mean that the other one would receive aid. So the nature of this type of claim makes that it's frequently rejected. There is also a high burden of proof, meaning, for instance, in the damage cases, I don't know if I told you, but in the private enforcement cases, there were only 6 cases which were related to damages, which is barely nothing. I think the same trend was observed in the previous study, which is a pity, as we said before, but this is linked maybe to the high burden of proof, how to prove that there is a causal link, how can we prove the damages. I think in cartels we have very clear directives from the Commission on how to calculate damages. It's absolutely not the case in state aid. And then you have also the presence or absence of parallel Commission procedures. Sometimes when there is a case going on with the Commission, the national judge prefers not to say anything in order not to interfere with the parallel Commission procedure. For instance, if we opened a case, but we did not yet close it, so the national judge waits in a way for the outcome of the Commission investigation. Which are the best practices? This was also an important outcome of the study. As regards recovery, we saw that, for instance, some member states had specific legal frameworks. So either they provide a specific law for one specific recovery decision. For instance, you have one Commission decision on a tax scheme. Well, they will issue a specific fiscal law to cover the effects of this precise recovery decision. Other member states have a more broad legal framework in which they simply say that in case there is a claim for recovery, this is the way how to handle it. The benefits of this specific legal framework is, of course, that the delays, etc., are tailored on the Commission decision. So it goes very, the delays are usually shorter than for another claim because they want to comply with the 2 and 4 months delay which is set in the Commission decision. What we also saw is that sometimes there are penalties for delays in recovery. So there is an internal state aid authority in some member states, where if the granting authority does not recover sufficiently quickly the aid, well, there are penalties attached to this behavior and which can hit the granting authority. And then we have also instructions about recovery which are included directly in the Granting Act. So if there is a contract for granting of a subsidy, sometimes the grantor of the aid already provides instruction in case the aid would have to be recovered. Maybe we come back to this schizophrenic approach which was mentioned before. It may sound strange that the granting authority issues instructions in case it's an aid. Maybe it would have been better to notify in that case, but okay. The main findings also regarding the control mechanism and the jurisdictions, we see that there were sometimes ex ante and ex post national control mechanisms have been put in place, especially since a lot of aid is now granted via the general block exemption regulation. So it's very useful. Sometimes there is a screening made by the national authorities. It's not a binding assessment, but it can help already to draft in a better way the aid. You have also ex post control mechanism. It was very clearly highlighted in the Esti-Pagar case law that there was a mechanism put in place to control ex post the granting of the aid. Sometimes you also have rules clarifying which jurisdiction is competent. I think in Italy, for instance, they have specific competences for administrative courts. as when it concerns state aid recovery, which is a very good practice. And then there is one member state, I think it's Estonia, where they have a type of proceedings which is guided by the principle of investigation, meaning that the national court, in a way, helps the plaintiffs to better structure their arguments, to give more documentation about the infringement of 108.3, etc. So this is also a very good practice. We don't know if it has ever been used, but at least in theory, it exists. As I said before, there are some cooperation tools, the request for opinion and the request for information. So that means that a national judge can send a request to the Commission. When it's a request for information, he can simply ask, what is the state of play? Is there a case open? When do you intend to make a decision? All these type of things, and usually we have to reply within 1 month. As regards the request for opinion, then it's a bit more difficult. We have a 3 months delay because, well, it's not a factual information. The judges come to us and ask for an opinion. Do you think that this type of measure is illegal aid? How do you see this? Do we have precedents, etc.? That's much more difficult. But voilà, it also exists. And then we have the third possibility, which is the amicus curiae, where the Commission intervenes directly with the national courts. To give you some figures, since the last cooperation notice, there have been 7 requests for information. You see 7 requests for information, 21 requests for opinion. So here you see the member states who have asked for an opinion. And as regards the intervention amicus curiae, between 2014 and 2017, there have been 20 amicus curiae interventions, which is not a lot, and many of them were related to the Mikula case, where Kai Strockmann will speak a bit more. How do we explain that there is such a low use of the cooperation tools? Well, basically, judges are not always aware of this possibility, so we have to do some advocacy about it. We also have to work on the delays. In theory, it's 1 month, 3 months, but we know sometimes it may take a bit longer. So this, of course, is a deterrent for the judges to use these cooperation tools, because in the meantime, the case doesn't make any progress. Some judges have also indicated that the procedure was unclear, the contact points were unclear. So for the time being, we should really invest a bit more on advocacy. Just the last slide. What can we do now with the results of the study? Well, we have a mandate to review the current cooperation notice. We are working on it, trying to see what can be improved. Probably if we issue a draft notice, there will be a public consultation where we really expect comments from the different member states and from the different parties interested. So yes, maybe next year I will present you the new notice, I don't know. But I think we are really insisting on the need to involve more the national judges. As said before, national judges can provide more concrete and quicker results than the Commission can. So it's really the cornerstone of a correct application of state aid law, with the direct access from the parties, with a perfect knowledge of the markets and of the legal situation of the member state concerned. So maybe we should invest more in training or create specialized courses. All options are open for the time being, but we are working on it. Voilà. Okay, so many thanks for listening to this second presentation.